We looked in the last lecture at the Criminal Appeal Act of 1968. We're going to stay with that piece of legislation for the time being and look at it a little bit more at this question of what makes a conviction unsafe. Because you'll remember in the last lecture that the effect of the 1968 Act was to consolidate all the previous common law reasons for claiming that a conviction could be unsafe, and created one statutory test, which is whether or not the conviction is unsafe, in the words of the legislation. So this really is the only question that now matters. Is the conviction you're considering safe or unsafe? No matter what you demonstrate about what went wrong with the trial or what new evidence you might have, it won't mean anything at all to the Court of Appeal unless you can demonstrate to them that the conviction is unsafe because of the new information you're bringing forward or because of the argument you're making about what went wrong previously. So we're going to look at a few different ways that a conviction can be found to be unsafe. And as we go on through the course, we'll review some Court of Appeal judgments which apply this legislation, and we'll see some of the different examples where cases have been found to be, or convictions have been found to be unsafe. But the first one, probably the most intuitive one, the one that most people think of when they think of people being exonerated for crimes they haven't committed, is fresh evidence. Now, fresh evidence is new evidence, for want of a better word. It's evidence that hasn't been adduced in the trial before, and for reasons that the lawyer might argue about, it's evidence that the lawyers consider render the conviction unsafe. But the Court of Appeal do not have to consider any new evidence that you might bring forward. So let's think about this in a practical scenario. When we're working on our cases, it might be that we get a new witness coming forward and saying, well, I know that this person didn't commit this crime. I know that someone else did, or they might be saying, I know that this person didn't commit this crime because they were with me at the time of the offence. The Court of Appeal certainly doesn't have to consider that evidence, and it's certainly not the case that simply because you have some new evidence to put before the Court of Appeal, the Court of Appeal will immediately take it as read, or will simply quash the conviction based on what is said in that witness statement. There is quite a strict set of statutory criteria that the Court of Appeal will apply before they consider fresh evidence. And really what we're looking at here is what constitutes fresh evidence. What is it that makes a piece of evidence fresh in the eyes of the Court of Appeal? And it's important to remember that even if the evidence meets the statutory criteria, the overall question that the Court of Appeal will be asking themselves is whether or not the conviction is unsafe. So even if you manage to get through the statutory criteria for admitting fresh evidence, and if the fresh evidence is admitted in the course of the appeal, then the overall question that the court will return to is whether or not the conviction is safe or unsafe. And we'll see in the next lecture how this was applied to the case involving the TV entertainer Rolf Harris, who recently had a conviction quashed based on fresh evidence. So the criteria for admitting fresh evidence is contained in the Criminal Appeal Act of 1968, and it's contained in section 23, which is not a number that's featured in this slide, but you'll just have to take my word for it that it's section 23. And it says that the Court of Appeal shall, in considering whether to receive any evidence, have regard in particular to. So the question that the court is asking itself is whether it can receive the new evidence, whether it can consider it in the context of the appeal. And the evidence has to meet these four criteria before the Court of Appeal can receive the evidence. So what we're going to do, we're going to go through the four criteria and consider each one in turn and consider what each one means in practice. So first of all, the first question that the court will ask is whether the evidence appears to the court to be capable of belief. Now this is an interesting phrase. Capable of belief really just means is the evidence such that it can be believed? I'll give you an example of what might be incapable of belief. If, for example, I produced a new witness statement saying that my client didn't commit this murder, it was actually aliens who came down in a UFO and zapped the victim with a laser gun. Obviously, that evidence is not going to be capable of belief because it's completely irrational. But a slightly more nuanced version of that is where If a witness comes forward and says, well, this defendant couldn't possibly have committed this crime because they were with me in the course of when the incident was meant to take place, and we were actually in Spain together, then if at the same time there was, for example, CCTV evidence of the defendant being in this country at the moment of the killing, perhaps undertaking the killing himself, then the Court of Appeal is simply going to say, well, this is incapable of being believed because it is contradicted by objective third-party evidence. So it has to be capable of belief. There has to be a possibility that the evidence would have been believed, and that, to me, seems like the most common sense aspect of this test. You have to be able to believe that the evidence is correct and accurate. Now, section B says whether it appears to the court that the evidence may afford any ground for allowing the appeal. Now, what this means is not just any old evidence is going to do for the purposes of meeting the fresh evidence test. What's required is evidence that gives the court reason to believe that the conviction may be unsafe. So all that is required to receive the evidence is that the evidence may afford a ground. It's not a determinative test. It's not saying that the evidence must render the conviction unsafe in order for it to be admitted. What it's saying is that it appears to the court that the evidence may afford any ground for allowing the appeal. So all that really means is that the evidence that's being admitted can't be completely irrelevant to the question of whether or not the conviction is safe or unsafe. It has to have the possibility of affording a ground of an appeal. So let's take a hypothetical case. Let's talk about a murder case where our client has been convicted of shooting someone in a sweet shop, and he produces evidence that says, well, in the hours after this murder took place, I actually went to visit my mum, and this is fresh evidence because, for example, it contradicted the prosecution assertion that I went home after the killing. Well, the Court of Appeal aren't going to look very kindly on that because, on the face of it, it doesn't offer any grounds for allowing the appeal. It merely demonstrates that one particular isolated aspect of the prosecution case might not have been correct. But in order for the court to consider the evidence, it has to be evidence that may afford any ground for allowing the appeal. Otherwise, it won't meet this test under section 23(2)(b). So hopefully that's relatively clear. Section C says whether the evidence would have been admissible in the proceedings from which the appeal lies on an issue which is the subject of the appeal. All this section requires is that the evidence that's going to be considered by the Court of Appeal must have been considered admissible in the context of the Crown Court proceedings that's being considered. It wouldn't make any sense for the Court of Appeal to consider evidence that couldn't have gone before the Crown Court in the course of the trial. So what do we mean by admissible? Well, depending on where you are at with your legal studies at the moment, you may well have already interacted with some admissible and inadmissible areas of evidence. We know, for example, that hearsay most commonly is, on the face of it, inadmissible in criminal proceedings. So if the Court of Appeal was coming to consider some hearsay evidence, for example, they would have to consider the separate test of whether the evidence would have been admissible in the Crown Court proceedings before they can consider it in the Court of Appeal proceedings. And that makes a degree of sense too. It doesn't make any sense to say, well, the Court of Appeal should consider this evidence if it couldn't have been considered in the trial that the Court of Appeal are considering. So yeah, in order to pass test C, the evidence must have been admissible in the proceedings from which the appeal lies on an issue which is the subject of the appeal. All that means really is that it has to be admissible on the issue that's being considered by the court. So, for example, if the issue of the appeal is the whereabouts of a particular defendant, then the evidence has to be admissible on that point. It has to be, it's not just you can't simply say it's admissible evidence on the, in general terms. It must be admissible on the question that is the subject of the appeal. But the key word to bear in mind in the context of 23(2)(c) is that it's admissible in the proceedings. So that's the key word, admissible in the course of the proceedings. And then D is a real stumbling block, actually, which requires that there be a reasonable explanation for the failure to adduce the evidence in the previous proceedings. So what this requires is that there has to be a reasonable explanation for the failure to adduce what is now fresh evidence in the course of the old proceedings. Now, practically what that means is that whenever you try and adduce new evidence in front of the Court of Appeal, you're going to have to explain to the court why it is that the evidence wasn't adduced in the course of the first trial. Sometimes that's very straightforward. If, for example, you are bringing forward new DNA evidence as a result of technological advances, then it's going to be relatively easy to convince the court, well, look, the technology simply wasn't there at the time, and now that the technology has moved on, that the evidence is here, and that's the reason why we couldn't have it at the time. But the question becomes a bit more tricky when, for example, you are seeking to adduce expert evidence that wasn't adduced in the course of the original trial. So to use a practical example, let's imagine that in our sweet shop, where our imaginary defendant has been convicted of murder, there is some CCTV that's a little bit blurry. And you now bring forward evidence that says that the video has been clarified and there's reason to say that the person in the footage is not your client. The Court of Appeal are going to legitimately ask, well, why wasn't this investigation undertaken in the course of the trial? Because one obvious explanation is that the client was in fact guilty of the crime and was providing instructions to his lawyers, or the option might have been considered, and the defendant might well have said, look, I don't want that material enhanced because it will show me in that footage. So often tactical decisions are taken in the course of the trial, but the Court of Appeal justices are very reluctant to intervene with. And so this is a way of the Court of Appeal trying to get an understanding of why a particular decision wasn't taken in the course of the first trial. And if they're not satisfied that there's a reasonable explanation for the failure to adduce the evidence in the first trial, then they're entitled to say, well, this was just a tactical decision of the lawyers, and we're not going to consider it at this stage. So you'll see in the next lecture how these criteria are applied in practice and what happens when new evidence comes forward and the Court of Appeal is charged with considering whether or not to quash a conviction based on fresh evidence. But these are the four criteria. The key words you need to remember are capable of belief, afford a ground of appeal, admissible, and reasonable explanation for failing to adduce. They're the four key criteria for admitting fresh evidence. Now, there's some cases here that you might want to look at. Arne Erskine, Arne Williams, which all look at the criteria around fresh evidence. I'm not going to go through those in detail at the moment, but you can have a look at those for yourself. Again, there's R. Beresford there, which relates to the question about reasonable explanations. So go away and have a look at R. Beresford. I'll make that available on Slack as well, so you can have a look at that. But these are the two key cases around fresh evidence that you may want to consider. And again, another extract from Archbold, which you can go back and have a look at in the slides and look up some of these cases if you like, just to develop your understanding of those criteria. Let me slide back through these slides. Okay, so the other possible ground for arguing that a conviction is safe or unsafe, and again, this will be the subject of a later lecture, so I'm not going to focus it on too much detail here, are judicial directions. So as you start to read through your casework, you'll read through what's called a summing up. And a summing up is a speech given by a judge at the end of a case, which explains all the relevant areas of law to a jury, and then all the matters of fact. So judges make speeches at the end of a case called a summing up, and the summing up will direct the jury on as I say, the relevant areas of law and how they should apply the law to their thinking. Importantly, the judge will distinguish at the outset of that speech between their role as judges, as the tribunal of law, and the role of the jury as the tribunal of fact. What that means is that it's the jury's job to decide what facts are true or false, but it's the judge's role to tell how it should impact on their decision making. And what can happen is sometimes judges can just get those directions wrong. They can misdirect on an important area of evidence. And we'll see in a case later on in the course about how a recent case of the Court of Appeal considered a misdirection in the context of hearsay evidence. So various directions will be given by the judge on how they should approach the evidence in their case. And where judges make mistakes in summing up the law, those misdirections can be made subject to an appeal. But as should be clear to you now, the only reason why a conviction will be quashed following a misdirect is if that misdirection impacts on the jury's considerations to such an extent that the conviction can be said to be unsafe. And we'll have a look at in a bit more detail about when that can occur and what kind of questions the Court of Appeal will look at when they're considering that question. Now in lecture two, we're going to come on to speak about disclosure, and disclosure is probably the key area that we're going to be looking at in the context of appeals, because often it's disclosure failings that can give rise to the possibility of an appeal against conviction. No doubt you would have seen in the news very recently a whole spate of headlines around disclosure failings. So hopefully you have some idea about what I'm talking about when I talk about disclosure. So I've said here a common ground of appeal is where there has been a failure of disclosure, and that the disclosure process governs the sharing of information between the two sides in a criminal case. So the disclosure process is that process through which the prosecution gives information about their case, governed by a particular piece of law called the Criminal Investigations Act of 1996. Sorry. We'll be looking at that legislation in a lot of detail in the next lecture, so I won't go into it here. But just to say that if the prosecution do not undertake their disclosure obligations properly, then a case may be subject to an appeal, and that appeal will be successful if it's found that the disclosure failure impacts on the safety of the conviction. So we'll come on to speak on that in lecture 2. So that's sort of the main areas that you might be looking at when you're looking at a conviction is safe or unsafe. And we'll see in the course of our casework that there's a whole multitude of other areas as well. But that's really the most common. Fresh evidence, judicial directions, and disclosure, I would say, are the most common areas in which appeals tend to be litigated. But having spoken extensively about the Court of Appeal, we now come on to the tribunal you're actually going to be working with, because you won't, on the whole, at the clinic, we don't actually use students to work on appeals, primarily because working on appeals requires you writing to a court, and writing to a court is what we call regulated work, so it has to be done by a solicitor. But the Criminal Case Review Commission is the commission which exists after the Court of Appeal. It's that tribunal which exists to consider any case which has been dealt with by the Court of Appeal, which has been subject to where it has been completed and disposed of and unsuccessful, but which for new reasons there seems to be a miscarriage of justice. So it's a commission set up to deal specifically with miscarriage of justice. And it was established in 1966 to actively investigate the possibility of miscarriage of justice. So the key point about the CCRC is that it's not a court. It's a commission that is set up to investigate. And for that reason, the CCRC are given a whole multitude of powers to compel the production, investigate the possibility that someone has been wrongfully convicted of a crime. Now, if you go and Google the CCRC, you'll see mountains of criticism about the way the CCRC work, that they're very slow, all sorts of different issues. I'm not going to go into that at all. I'm just going to consider what their role is and the statutory framework that governs their work. So you can see in a bit more detail the questions we're going to have to be asking ourselves when we come to the casework. So as I've said, the CCRC can only consider a case that's been dealt with by the Court of Appeal, and it considers new matters which have not been considered by the Crown Court or the Court of Appeal. So specifically, the most important power that the CCRC has is the power to make this word here, what's called a reference. So the 1996 Criminal Appeal Act, as opposed to the 1968 Criminal Appeal Act, the 1996 Criminal Appeal Act, which established the CCRC, gives it the power to make a reference back to the Court of Appeal, which effectively means that it can take an appeal that's been disposed of by the Court of Appeal and refer it back to the Court of Appeal to be reconsidered. And Section 13 of the 1996 Act gives the conditions for making a reference. So it's under this piece of legislation and this section of that legislation that the conditions for making a reference are given. So let's have a look at that in detail. So conditions of making a reference. A reference of a conviction, verdict, finding or sentence shall not be made under any of the sections 9 to 12 unless the Commission consider that there is a real possibility, I was going to underline that the conviction, verdict, finding or sentence would not be upheld were the reference to be made. So these are the two key words here, real possibility. The CCRC is considering whether or not there is a real possibility that were they to refer the case back to the Court of Appeal, the Court of Appeal would quash the conviction. So what the Commission has to consider is whether, if they referred the case back, there is a real possibility that the conviction would not be upheld. So it's written in slightly confusing language, but the sum total of it is there a real possibility that the conviction would not be upheld if they made the reference? And in other words, reading between the lines, what that means is there a real possibility that the argument that's currently before the CCRC means that the conviction is unsafe? Because although that's not the test they're explicitly considering, whether or not the conviction is safe or unsafe, they're really considering whether or not there is a real possibility that the new argument renders the conviction unsafe. Because that would mean that there was a real possibility that the conviction would not be upheld were the reference to be made. Section 13b, the Commission so consider in the case of a all these three sections are important only in as much as we're not going to be considering sentence appeals, so we don't need to worry about that. Here, in an appeal against conviction, finding or sentence has been determined and leave to appeal against it has been refused. So this just means that the CCRC can only consider a case once the appeal against conviction has been determined, or leave to appeal against it has been refused. So what that is saying is that in order for the CCRC to even look at a case, it must be that the appeal against the conviction has been determined, or leave to appeal has been refused. So just remember that distinction that we looked at earlier between leave to appeal and actually appealing. Here it just makes clear that in the event that an appeal has been determined, or where leave to appeal has been refused, that's where the CCRC can step in and intervene. So the key points to remember about the CCRC is that they deal with cases after the Court of Appeal, and that the test that they will be considering is whether there is a real possibility that the conviction would not be upheld if the reference was made. One case you might want to go away and look at is the case of footballer Ched Evans, who had his case referred back to the Court of Appeal by the CCRC, who eventually, the Court of Appeal then went on to quash his conviction. So the two key institutions that we've looked at in the course of these two lectures are the Court of Appeal and the CCRC. The CCRC deals with cases where the Court of Appeal no longer has jurisdiction over them, where the Court of Appeal have actively dealt with them. So you need to make sure that your client has had their appeal disposed of, or their application for leave appeal disposed of by the Court of Appeal before they're considered by the CCRC. The CCRC will only consider new evidence or material or arguments that hasn't been considered by the Court of Appeal or the Crown Court before. So it must be something new. We've also looked at the various areas that you might want to raise with the CCRC. So specifically where there is fresh evidence, 2, where there is some failure in the summing up or some misdirection of law, or 3, where there is a failure of disclosure. And disclosure is the subject of our second lecture. So thank you very much for sitting through these first 2 lectures. I hope they provide some assistance to you in your casework, and I'll see you in lecture 2.